Good morning, Mr. Naaman, good morning.
Good morning. May it please the court. My name is Steve Nyman. I represent the defendant and appellant, Severo Figueroa. I didn't have the privilege of representing him in the lower court. There's a few issues before the court. I'd really like to focus on the first two. And in essence, they blend together, that being the Crawford violation and the failure of trial counsel to move to exclude the testimony of the immunized witness. Just as a backdrop against this case, this is really a two-witness case against Mr. Figueroa. The first witness was a friend of the victims by the name of Miguel Rodriguez. His street name was Blackie. He was the only percipient witness. He comes with a lot of baggage, and his testimony should certainly be viewed with a lot of skepticism. I'd just like to quickly, if I could, recite a few points that I'd like the court to keep in mind as we go through the argument. The first was that it wasn't until the time of trial that Mr. Rodriguez had mentioned that he saw a gun in the defendant's hand. He also mentioned that the shooting was point-blank range and there were 3 shots that were fired. Ballistic evidence showed that this was not point-blank and that the shooting was actually through the car door. When police arrived at the scene, it was Mr. Rodriguez who essentially waved them down and told them that they were shot at as they were driving down Broadway in Lawrence. This fellow had an extensive criminal record. He had pending cases that were null pros, in essence, to sort of motivate him to cooperate with the prosecution. There was no soot or stippling on the victim. The medical examiner testified that if the shooting was within 18 to 24 inches, you would expect to see stippling on the victim.
Except that the fact of clothes makes a difference there.
It certainly does, but there was also no evidence that there was any kind of stippling on the car. So even if you say that it was, and the shooting was through the car door, you would expect to see something on the car showing that this was fired from close range. There was no evidence of that as well. He also claimed that he didn't know who the shooter was, and the only time he, prior to going before the grand jury, he mentioned anything about the defendant being the shooter was to the victim's brother, a fellow by the name of Hector Rivera, but the judge made it very clear when that testimony came in that was for credibility purposes only. That was not for substantive purposes.
Wasn't there some testimony that the defendant and the victim had words earlier that night?
It wasn't really earlier that night. It was at the time that this whole thing.
At the time.
Everything
words.
was pretty much contemporaneous.
Yes.
The gist you get from the transcript is it happened within a matter of seconds, not even within a matter of minutes. There was the slap on the back of the car, the sort of exchange, if you will, and then the shots being fired. That was one version. The original version, however, was the two driving down Broadway and the shots being fired and the victim sustaining gunshot wounds, and the passenger was the one who applied the emergency brake as the victim was fading, got the car to come to a stop and eventually waved down the police. Well, this really, against that backdrop, I'd like the court to really take a look at the Crawford violation.
Now, the district attorney says, of course, Crawford wasn't decided when this trial occurred, and I know the defense lawyer made a confrontation objection.
Right.
Right?
Right, absolutely.
So his rights are, preserved. But he says, and what's wrong with this, that witness testified at the trial.
Well, and I would...
was available, was cross-examined. I thought Crawford didn't apply to those kinds of things.
Well, I would say there's a huge difference between testifying and merely showing up to court and getting on the stand and saying, I don't remember.
Why?
Well, because
Because Crawford just says you don't. If you're there, the issue drops out.
Well, it certainly, unfortunately, leaves room for a lot of abuses. I mean, the whole idea is that you're permitted to cross-examine. If you think about the context of this case...
But you were able, your defense counsel was able to cross-examine.
He absolutely was able to cross-examine, but you don't want to cross-examine him with his grand jury testimony and ask him, isn't it true that you did have a memory, and your memory was that the defendant admitted having done this to you?
But this
Well,
happened-
so
That's-
aren't you better off then?
yeah.
Well, you're not better off, because what's happening is you're getting a statement to essentially come in for substantive purposes through the back door. You're enabling this guy to get up and say, I don't remember. He can go back to Lawrence, he can save face with all of his gang member friends on the streets saying, I didn't testify, and guess what? His testimony really did come in through the grand jury minutes.
But
It
what,
all-
Mr. Nyman, why can't you question him not about whether or not he remembers, but why can't you have the grand jury minutes, and why can't you say, now how far, I mean, all the usual kind of cross-examination about the substance of the grand jury minutes?
Well, the substance of the grand jury minutes was the stuff for which he was originally immunized. And it was all inculpatory as far as Mr. Figueroa was
Sure,
concerned.
defense counsel cross-examined him. He just didn't sit there and say, well, I've got nothing to ask him.
He did cross-examine him.
And he
but
brought out all the, I mean, didn't he get to bring out many of the things that were consistent with the defense? That is, that this was a setup?
Well, he was able to, well, more or less he was able to bring out that the immunized witness had taken drugs before he testified before the grand jury. You're talking about setup in terms of
The leadership of the
the gangs?
gangs.
I don't think that was of major concern to the defense at the time. The defense was more concerned about, did this happen as Rodriguez initially said, as they were driving down Broadway, or did it happen, as he subsequently said, in front of the house on Washington Street at point-blank range? So I don't really think the focus was the gang membership.
This is really the Commonwealth's nightmare, that they cut a deal with a guy, let him off on a more serious charge. The only thing he's left with is perjury. The worst thing they can do is indict him for perjury. The guy's cut his deal, and now he doesn't have to say anything.
Well, that really gets into the next aspect of this, which is why would the Commonwealth then be permitted? And I know that defense counsel didn't object to it, but that's why I raised it under.
It goes to credibility. That's all that's left. It's a credibility issue
For who?
for everybody.
For the Commonwealth or the defense?
For everybody.
Well, I think that for the Commonwealth, they've got their credibility. They've got.
Oh yeah. They've got a lot of credibility on this one.
Well, they've got the guy testifying before the grand jury. They've got his grand jury testimony coming in substantively.
And when it really counts, the guy does a puff on them, a powder puff.
And the
literally.
judge is instructing the jury that the fact that this defendant was indicted by the grand jury doesn't mean anything. You can't count it at all. So to the extent there's any grand jury testimony, the judge is just about telling them to discount it.
Well, I don't think he was telling them discount it. It came in substantively, and I think the
I
instruction was
understand. I understand that, but the judge tells them at the same time in his final instructions, and perhaps at the beginning of the trial, the fact that this defendant has been indicted by a grand jury. Do not consider that in your, in your discussions as to guilt, which is proper. So I'm just saying the jury doesn't understand the niceties of substantive and things like that.
I think as a more practical matter, what they understand is that this was somebody who had no trouble coming in and testifying when he wasn't in front of a jury and not being confronted by the defendant. And now all of a sudden, when he's confronted by the defendant, he's afraid, so he's not going to testify. I think that sends a very, very negative message to the jury insofar as the defendant's concerned. That this guy is a bad guy, he's dangerous, I'm petrified to testify in front of him, but when I've got the confines of the grand jury and the protection of the Commonwealth and no jury and no open court and no defendant, I'll say what I have to say.
Mr. Nyman, if the Commonwealth uses grand jury testimony, it's out on the street, so to speak, that this witness in fact testified against the defendant. I mean, can't the defense attorney make that argument? Did the argument that you just made about, when he had the protection of the Commonwealth, he told the truth, was that an argument that was made by the Commonwealth in closing argument?
No, they didn't, not in that context, no. I mean,
But
yes, it was made that that's what happened and that's the truth, and he came in under a grant of immunity. But
Could I just go back to my question, which, at least for me, you didn't really answer. The grand jury testimony comes in, and the jury hear, and he's sitting on the stand, and the jury hear that, it's a drive-by shooting. Why can't you cross-examine him as if he was saying those same words in court? In whatever way defense counsel wants to cross-examine.
Well, you can do that. That's not, I'm not saying that you can't do that. You certainly can do that. Now, obviously, you wouldn't do that, because all you're doing is restating and reinforcing the Commonwealth's case, that you're saying, no, I don't want to get this from a transcript. I want to get this from the defendant's mouth. Make him come here and say
In the
what he
witness's
said.
mouth.
I mean, I'm sorry, from the witness's mouth. Make him come here and say what he says was true and what he's immunized for. And he didn't do it. And the judge found during the voir dire, this guy's lying, which brings you to the next question. Why, if the judge finds he's lying before he testifies to the jury, do you then permit him to testify? That cuts right against Massachusetts Rules of Professional Conduct 3.3e. Say, well, I don't believe him, but go ahead and put on his perjured testimony. And you know what? When he then turns around and says, I don't remember, go right to the grand jury minutes.
But that's
That's inappropriate right there.
The judge, I mean, if one accepts that argument, then one could never use grand jury testimony when the witness is saying, I don't remember. I mean, it would be a total because
No, there's a difference between not remembering and lying about I don't remember, and then taking that lie and perpetuating it before the jury. That's the problem. And the judge recognized that. And he was a seasoned trial judge who had been through a lot of this and understood this stuff, and he made a judgment call, and it was not...
But I thought that what he was doing was, what Judge Bone was doing was articulating that the reason I'm going to allow the grand jury testimony to be used is that I find, I don't credit this failure of memory, that it is a manufactured failure of memory.
Right, under the third prong of Day or Clemens or whatever.
It's Cenero, I think.
All right, whichever one he used.
So putting in the grand jury, that's not the grand jury's the grand jury testimony that the judge is finding was perjured.
Right.
The judge is finding that the testimony in court is perjured.
Absolutely.
And that creates that just provides a foundation for the use of the grand jury testimony. So he's not violating an ethical rule.
No, but that's not, I don't believe that's what Day or any of its progeny stand for. I think it's a truly don't forget, not you're in court lying, so let's go back and get what we perceive to be the truth. Your grand jury testimony, that's not what it said.
I take it, Mr. Nyman, that you would have something like the following. I don't know, but the judge concludes that he does not believe that this defendant can't remember, that he's lying. The judge then says, I'm not going to permit him to give testimony which I think will be perjured testimony. So then you fall back onto Day, and the grand jury minutes come in because he's not going to let him give perjured testimony.
Well, I follow the
It's
logic,
really-
but he shouldn't have been able to, his testimony shouldn't have been permitted in the first place when you know that the only thing he's going to say beyond his name is a lie.
Well,
And essentially the
we
Commonwealth
usually don't
is
talk about it in those terms. Of course, that's realistically what it is, but what we're talking about in trial advocacy terms is prior inconsistent statements.
But Judge Bone talked about it in terms of being a lie.
No, he did not use that word.
He said he's lying.
Well, anyway,
He said, I find that he's lying.
well, I think we understand that issue.
But in any case, that essentially goes on to whether or not there was a substantial likelihood for the failure to challenge the permissive use of Lavoie as a witness in the first place. And that, again, sort of gets back to what I was just discussing. Those are essentially the two major issues in the case. There's a couple of additional issues. The failure to address the presumption of innocence in accordance with the statutory requirement to the venari before trial. That was left out. I have equated that to a sort of structural error under Sullivan versus Louisiana, that your failure to inquire to the jury about that ahead of time is not curable. It's not subject to a harmless error analysis. And finally, the last issue was evidence of flight as consciousness of guilt. The Commonwealth talks about flight as being flight from the crime scene, but during the discussions with the judge in the charge conference, flight was referred to as Mr. Figueroa leaving the jurisdiction, leaving the country. And that Sergeant Marks really never made the proper foundation. He had said that he went to an unknown address in Lawrence, the wrong address in Lowell, and he contacted the defendant's mother in Chelsea. That was the extent to which that he had made an effort to look for the defendant after.
What about the fact that he was found in, was it Dominican Republic afterwards?
And my argument was you don't impute knowledge to him of something that he claims he didn't do by virtue of the fact that he's out of the country.
But we traditionally permit the arrest of the defendant in parts unknown to be considered as consciousness of guilt. And you're saying that it should first require how would you establish that he knew that he did it, other than by the proof you present, the evidence you presented at trial?
Well, my understanding was that under Tony, a little bit more of a foundation had to be made rather than just finding the individual out of the jurisdiction.
Okay.
Judge Bosworth, if you, I can probably find a citation to
just-
Judge Bowen's. I actually think that
You quote some of it, and I just don't remember the word lying being in there, but I will check it.
I'm just looking for the portion of my brief where I specifically quoted. I think it's after page. I think it's after page 33, but I am virtually certain that that word is there. It actually
I'm sure
may be
your
in this,
memory is better than mine, so.
Well, we can find it.
actually may be in my statement of facts. But I can, if the court so desires,
But
I
find that
can-
the witness has falsified his lack of memory.
that was in the body of the brief. I actually think he used the word lie
All right, I'll find
earlier
it.
on.
Well,
Thank
we'll find it if it's there.
Okay. If there's any other questions?
Thank you.
Thank you, Mr. Nyman. Mr. O'Sullivan?
Doesn't the rule that if the witness shows up and testifies, the Crawford issue goes away?
Yes, that's correct.
That's pretty cut and dried, isn't it?
Yes, Your Honor. I mean, this court has identified the circumstances in which cross-examination has been so undermined as to deny the right to confrontation, and none of them are present here. Essentially, they are when the judge places improper limits on the scope of cross-examination, where the witness asserts a privilege, where there's a refusal to answer or cooperate on cross-examination. In fact, here the defendant didn't refuse to answer, or LeBoy didn't refuse to answer a single question. And finally, where there's a total lack of recall or a complete wholesale failure of memory claimed by the defendant.
Mr.
None of these
O'Sullivan,
occurred.
I confess I can't remember in Saniello or Evans. What's unusual here is the judge is making a finding beforehand that the testimony that this witness is about to give is perjured testimony,
No, that's...
right?
The finding he made was that he was falsifying a lack of memory, and that
So
must be
if he
made.
so testified, that would be false, correct?
I'm sorry?
If he so testified, that would be perjury.
That the witness testified and that the judge made a finding that he was falsifying a lack of memory exposes LeBoy to a perjury prosecution.
Doesn't the judge have to make that finding?
He must make that
Under
finding
scenario
before admitting
before
the
he can
testimony.
admit the grand jury testimony?
He must make that
That
finding
the,
under
He
scenario.
He doesn't have to make the finding that he has to make a finding that he can't remember, correct? Right?
He has to make a finding that not that he can't remember, but that he's in fact falsifying a lack of memory.
It's really a finding that is, to put it in a little better terms, his lack of memory is not genuine.
That's correct, Your Honor.
Because a genuine lack of memory does not entitle the Commonwealth to put in grand jury minutes.
That's absolutely correct, because there's no inconsistency between a present failure of memory and a past existence of memory. So under Cenero, it answered the question that was left open in Day as to whether you could treat as inconsistent circumstances where the witness is falsifying a lack of memory. So the finding must be made beforehand. It was, in fact, in this case, it was proper, and it's conclusive under Cenero. And the judge here based it on his demeanor.
So that takes care of that.
That takes care of that.
There's
The
no
Crawford
requirement that you instruct in advance on presumption of innocence, is there?
no such requirement
And
under
the
the statute.
instruction given at the end was impeccable.
It was, Your Honor. It was particularly strong. And I would just, as to the consciousness of guilt issue, I would focus on the piece of evidence that the judge highlighted in his instruction that was the basis for the consciousness of guilt instruction. I would suggest that that was a proper evidentiary basis for the instruction, and that is his arrest some 8 months after the crime in the Dominican
from
Republic.
that very fact, the passage of such a large amount of time, you can infer he wasn't just down there having a vacation.
What was he from the Dominican Republic? Or-
There's no evidence in the record as to whether he was from there or not. And the defense attorney properly brought it up in his closing that, look, you don't know why he's down there. He might have been down there with family. He might have gone on a vacation. You simply don't know. And the judge in his instruction adverted to the possibility, to the fact that that was a permissible inference from the evidence, just as the Commonwealth's argued inference was permissible.
That's the right way to instruct on it.
It's
Give
absolutely
the jury,
proper.
just say it's an inference you can draw, but you're not compelled to draw it.
Right. It's in accordance with the long-held rule that the judge can recite what the evidence was and discuss the possible inferences that may be drawn from it, as long as he doesn't argue himself for one or the other inference or suggest that one or the other was better. As to the evidence, I mean, there was a sufficient evidentiary basis for the consciousness of guilt instruction simply because there was record evidence that he normally resided somewhere in the United States, not the least of which was the fact that there was evidence he had a girlfriend here and that he was known by Javier Laboy from the clubs in Lawrence. If I could just go back a second to the immunity order, which the defendant claims was improperly given in light of the judge's finding of that he falsified a lack of memory. I would suggest that the two are essentially unrelated, and the decision whether to at some point seek to revoke the order of immunity was one that was vested solely in the prosecution. The decision to immunize him is inextricably wrapped up with the decision not to prosecute him and to essentially go for a larger fish, that is the defendant, in exchange for Laboy's testimony and to forego prosecution.
Well, let me
of
stop
Laboy.
you, though. I'm not very familiar with revoking a grant of immunity, but how could you revoke it after he's testified before the grand jury? He's already implicated himself, and there's enough there then to prosecute him based on what he said. So how could you revoke a grant of immunity after he's testified at the grand jury?
Yeah, it's not clear as to whether we even could at that point.
It doesn't
So-
make sense, it seems.
But it wasn't revoked here.
No, but I'm just saying theoretically.
Did he actually get the immunity before the grand jury or before trial?
No, he was not immunized before the grand
That's
jury.
what I thought.
He was immunized after his grand jury testimony.
Quite close to trial, I think.
Right. This was a sequence of events. He testified before the grand jury roughly a month after the shooting. He testified to an incriminatory version of events, i.e. that he had driven the defendant from the scene and the defendant had made the statement that, I just shot somebody, can you drive me out of town? On 9/11/2001, roughly a year later, he recanted this in a letter, and he stated that he drove someone else entirely from the scene, not the defendant, and he was under the influence of alcohol and drugs at the time, and he recanted totally his statement. Later, he was immunized. essentially. And he there testified consistently after the immunization with his grand jury testimony, and that is the incriminatory version. If there are no further questions about any of the issues, I'd rely on my brief.
Thank you,
Thank
Mr.
you.
Asano.